to Crime in Court. My name is Heather, and this is another episode of the Canton Cover-Up, the Commonwealth of Massachusetts versus Karen Reed. As you can see by the thumbnail here, we're on episode 40, the Battle of the Canine Experts or Not. Because the Commonwealth is trying to block the defense from bringing in any experts. Pretty much, they're trying to get rid of the defense. Turtle Boy on his live the other night made a comment that the Commonwealth doesn't like experts. Their experts are people like Marietta Sullivan, who came to testify about an Aruba trip and how Karen Reed was mean to her, which is true. That's kind of where, well, what she did. I mean, that's exactly what she did. Um, and it had nothing to do with the case, nothing to do with anything. So it shouldn't have been brought in because I think it was just very prejudicial, regardless. So we're here to talk today about the Commonwealth. We're going to read through the Commonwealth's renewed motion for reciprocal discovery and their motion to exclude defendant's expert Dr. Marie Russell. But as we read through, it's not just Dr. Marie Russell that they want to exclude, it's basically all of their experts. But even so, even if the defense didn't even put on a defense at this point in time, after the crap that they just pulled in court on Thursday, it's over. It's done. There's no case left. Even if Judge Bev lets this continue to play out until it reaches the jury, it's over because the prosecution defense purposefully tried to deceive the jury by using flipped, mirrored Sally Port footage, which led them to believe that the tail light that was visible and in frame was actually the tail light in question, but really it was the other tail light on the opposite side. We went through it in my last episode. I will tag it in this and put it in the description below. We went through it. We also went through Microdots, who did the, re-mirrored it or whatever you want to say, like put it in the right way. And then we watched it correctly. And they pointed out a bunch of different anomalies throughout and all the different time jumps. There were time jumps in the timestamps. So that was Thursday. But now um, we learned at the end of court on Thursday that the Commonwealth wants to exclude the experts for the defense when they start to put on their case. So we're going to read through that, and then I have some clips we're going to actually go through regarding dog DNA because I think the prosecution opened the door for this by bringing on the expert that they did. So let's read through this and then we'll go through all the different examples that I have, the clips that I have. All right, so the Commonwealth's renewed motion for reciprocal discovery, meaning they want the discovery from the expert witnesses, any reports or presentations that they're going to display, anything like that that they are going to refer to, they need to provide that discovery. But if they don't have reports and they don't have that kind of thing, and they're just going off of what the evidence is of the case, because they've reviewed records and things like of that nature, they don't really need. I mean, they have to say what their expert is going to basically be testifying to, but they don't really need to provide any kind of reports or anything like that. I mean, it's not required unless they're using the reports and they're going to refer to the reports. So, anyways, at least that's my understanding of it. If I'm wrong, please let me know in the comments below, but that's my understanding of the law of reciprocal discovery. All right, so on April 15th, 2024, the day prior to trial, the defendant provided the Commonwealth with a witness list which contains the names of civilians, police, defense investigators, and experts. On April 22nd, 2022, the Commonwealth filed the Commonwealth's renewed motion for reciprocal discovery and renewed request for voir dire of any proposed defense experts. So they want to be able to voir dire them, which basically just means ask them questions and determine if they think that they, are qualified or not based on their answers. All right, so during that week of jury impanelment, the defendant was ordered to comply with 1 week with Mass R Crim P 14. That's whatever statute that's criminal procedures, Mass R Crim Procedures 14. So that's whatever rule that is. All right, so on April 29th, 2024, opening statements were made and the trial testimony commenced. The defendant sporadically provided reciprocal discovery to the Commonwealth on May 1st and on May 7th. See Commonwealth versus Reynolds and a whole bunch of numbers. All right, a defendant's discovery obligations includes impeachment evidence allowing the defendant to withhold such evidence against a witness who is certain to be called to testify would undermine the discovery rules and allow attorneys to return to trial by ambush. Theatrics do not accord with our discovery process. And that part there was quoted um, from this case. But that's not necessarily a ruling in this case. That was just somebody who they're comparing this case to, so it doesn't necessarily compute. Um, the defendant has failed to comply with Mass R Crim P 14, which is their discovery rule, which requires the defendant to produce all intended expert opinion evidence, including all written reports and opinions that pertain to this case and the identity of anything upon which the expert bases their opinion. And that is Commonwealth versus Pava. Something provides for an automatic exchange of discovery regarding intended expert opinion evidence. The Commonwealth again renews its motion for reciprocal evidence. And I'm sorry, this is such a bad. I had to uh, darken the text on this, and this was it. Somebody had pasted it or posted it to Twitter and sorry X, and the photos were they obviously took photos of it or something because it's really all crooked and bad. So I apologize for the way it looks. It's hard to read for me, even. All right, so on April 15th, 2024, the defendant identified Chris Van E, PhD, as a potential expert witness in biomedical and mechanical engineering. The defendant proffered that, quote, Mr. Van E will testify regarding his opinions and conclusions regarding the Commonwealth's reconstruction and the EDR data obtained in connection with the case. I believe that is um, the EDR data is it's the data from her SUV, the dashboard, or, everything that it captures should be on it, meaning like stops and turns and running, driving 24 miles an hour backwards, which, by the way, I just want to stop and say, why backwards? Why backwards? If you're that angry at somebody and if you have intent to run them over, you're going to do it facing them. You're not going to run backwards over them. That makes no sense. You might go back, like, okay, you might run them over forwards and then go backwards if you really want to, like, get them, but you're not going to run them over backwards. I think, like, why nobody's asking this question, why backwards? Why would she run him over backwards? It makes no sense. No sense at all. That's why it went from, okay, one of the theories was they were going to say she got into a fight with him and hit him over the head with a glass. That's why there's glass pieces there from his cocktail glass, which we don't even know if that's the glass from the bar or not. And it could have been a glass from inside the house, but nobody checked, so we don't know. So it went from she hit it's a domestic thing, and she hit him with the cocktail glass to, oh, she ran him over, but because she had the cracked tail light, they noticed that, and I think they went with it, and they're like, oh, we're just going to use that, not thinking that a tail light needs a lot of force to be cracked, especially these particular taillights, because they are supposed to be almost like virtually indestructible, which is why I think there were so many cut shots in the surveillance camera because they had a hard time getting it out. And according to Sean McDonough, and I think Turtle Boy has reported on this too, there is going to potentially be an officer that from Canton PD that just happened to be like walking through the Sally Port, and they asked him his opinion on how to get that off, or he interjected, was like, you want to get that off, you need to do X amount of things to get it off. So he maybe gave them the knowledge to do it or something. He might be testifying. That's, I can't like totally back that up, but that's kind of something that I've heard in the law tubes. So yeah, my question to you guys is why backwards? Why backwards? It doesn't make sense. If you're going to run someone over, you want to run them over, you're going to do it forwards. It just, period, end of story. I mean, I don't, anyways. All right. Unless they just happen to be there and you happen to, but even then, like you want to look at their face, I'm sure. Like you want to look at them and be like, you want to, if you're that maddened to run someone over, that's probably the way you're going to do it. And backwards, like they could just run out of the way, I would think, because it would be harder to maneuver backwards and you have to be going slower. But regardless, he's the expert in the EDR. This guy Van E. He will testify to the chronological data derived from the EDR, including key cycles and triggering events from time period in question. That includes accelerating, braking, stopping. All of those things are going to be in this EDR. And this is a defense witness that the Commonwealth is trying to block. Um, and they say, however, this description fails to comply with Math R. Crim P 14A, which requires the defendant to disclose the opinion rendered, all intended opinion evidence, and any reports prepared by the expert. Okay. You guys all know that the defense's opinion is that Karen did not run John over and someone beat him up in the house. So, I mean, you can probably pretty much guess what they're going to be testifying to. I mean, and it says right there, key cycles and triggering events. That's what he's going to use the EDR report. I don't understand what Lolly is so confused about here. I get it, but I don't know. All right, defendant also identified three experts from ARCCA LLC, which is Daniel Wolf, PhD, Andrew Rentschler, PhD, and Scott Klein, BSME, as expert witnesses in accident reconstruction. The defendant indicated that each expert will testify consistent with report in possession of the Commonwealth, pursuant to Mass R. Crim P. The Commonwealth again moves for the defendant to produce all written reports and opinions that pertain to this case and the identity of anything upon which the expert bases his opinion. Um, Again, aren't they going to be looking at the vehicle itself, the conditions it's in, and the EDR report? Like, I don't know what's so confusing about that, but okay. The Commonwealth also moves for the defendant to specify what each of the three experts did, what their independent opinion is, and what each expert would testify to. Do they? Do they have to do that? Does anybody know for sure? Is that the rule? Furthermore, a voir dire is necessary to determine whether each of these four proposed experts are qualified to render an opinion about crash reconstruction, whereas all four proposed experts are biochemical engineers and not crash reconstructionists. So basically, because it doesn't say in their title or anywhere on their resume, crash reconstructionist, they want to exclude their testimony. I don't think that's how it works, Commonwealth, but okay. By the way, this motion is going to be argued. I believe we're starting at 8:30 in the morning, Monday to argue. So tomorrow morning we're going to start a little bit early so that the defense and the prosecution can argue this case or this motion. Sorry, saying all the wrong words. All right, so on May 21st, 2024, the defendant provided the Commonwealth with the curriculum vitae of Dr. Marie Russell. Here we go. An expert witness not previously disclosed. On May 30th, 2024, during the sixth week of trial, Attorney Little provided the following synopsis about Dr. Russell. She has reviewed the autopsy photos, grand jury testimony of Dr. Scorti-Bello, the entirety of the autopsy report, all reports associated with Chloe's prior bite history, photographs of the items in evidence, and the UC Davis DNA testing results and evidence submission. She is expected to be called with focused testimony related to the right arm injuries sustained by Mr. O'Keefe. Dr. Russell will testify that the wounds and injuries on Mr. O'Keefe's right arm are consistent with an animal attack, namely teeth or claw marks, or a combination of both from an animal. She will also testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or taillight material. She will base her opinions and conclusions in part on having treated hundreds of patients in the ER with injuries sustained from animal attacks, including dogs. And then the Commonwealth says no written reports or opinions from Dr. Russell were provided. Well, what do you think she's going to say, Lolly? What do you think she's going to say? I mean, this is just him saying, I don't like what she's going to say because it hurts my case, so I want her whole testimony excluded. That's what Lolly's trying to do here. A criminal defendant's constitutional right to call a witness on her behalf is not absolute and may be limited in the judge's discretion in the face of legitimate demands of the adversarial system. Commonwealth versus Dranka. Citation, oh, sorry. I need to read that part. The defendant filed the notice of experts one day before trial on April 15th and for Dr. Russell on May 21st, with a synopsis of her opinions over a week later on May 30th during the sixth week of trial. Okay, so keep that date in mind. On May 21st, they're ready to submit Dr. Russell as an expert witness. Keep May 21st in mind. All right, that's last month after some testimony may have been had at on the stand. All right, so with a synopsis of her opinions over a week later during the sixth week of trial. For violations of Mass R. Crim P 14, a judge may, in her discretion, bar these witnesses from testifying. This sanction may not be imposed without a judge's balancing the Commonwealth's interest in enforcing its procedural rules against the defendant's constitutional right to present evidence on her behalf. The Commonwealth moves to exclude Dr. Russell's testimony as the Commonwealth is prejudiced by the extremely late notice of Dr. Russell. The Commonwealth has called over 50 witnesses thus far, and a request for a continuance 7 weeks into trial is impractical. In addition, jeopardy has attached. The Commonwealth is furthermore prejudiced by the defendant's decision to elicit this testimony and the surprise it has caused. I'm sure it's not a surprise, Lolly. This has been their theory of the case, the defense's theory of the case for months and months, and they've been very public and vocal about it. So for you to sit there and say, well, this is just going to prejudice us and we weren't prepared for it, that's just a lie. That's just honestly, it's a lie. You can't say that you didn't know that they would have somebody to testify to John's injuries and to compare them to dog bites, but they don't want that. That's fine. Okay. during a final pretrial hearing on February 15th, when asked by the court whether there was any dispute about the canine's involvement or canine DNA, uh, I take offense to his wording here because it doesn't have any, it doesn't say canine. We'll get to that. I'm getting ahead of myself. When asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated no and that the defense was not pursuing such claim. That's not what they said. We'll watch that pre-trial hearing and you'll see. Okay. So it was not until April 29th, 2024, during opening statements where, contrary to the court's prior ruling, that third party culprit evidence was not admissible or appropriate for opening statements, Attorney Yannetti unfairly prejudiced the Commonwealth by arguing Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death. And that means that somebody else did. How? They're not blaming it on any particular person, and that wasn't, they're still allowed to say somebody else did this. If my client didn't do it, someone else did. And they're not pointing the finger at any particular person, but they're saying somebody else did. If they wanted to point the finger at certain individuals, they would need that third party culprit um, argument or strategy to be, I guess, approved by Judge Bev now because she needs to approve it. All right, so, and then surprisingly proceeded to proclaim that the defendant's injuries were consistent with a dog attack. In light of this, on May 15th, the Commonwealth called Terry Kuhn, a forensic scientist, to testify that there was no canine DNA present on the samples provided to her veterinary forensics laboratory. And we're going to watch her testimony too. Ms. Kuhn did not render an opinion about the cause or appearance of John O'Keefe's injuries, nor offered any testimony about whether John O'Keefe's injuries were consistent or inconsistent with an animal attack. Commonwealth is unduly prejudiced by the defendant's intentional delays in providing appropriate discovery and notice to the Commonwealth. Bad faith when failure to provide discovery is deliberate. They didn't do it deliberately and willfully, motivated by desire to obtain a tactical advantage that would minimize the effectiveness of cross-examination and the ability to adduce rebuttal evidence. Furthermore, the proposed testimony of Dr. Russell may necessitate a Daubert-Lanigan hearing where the defendant bears the burden of establishing that the proposed testimony would assist the trier of fact and that the methodology underlying the expert testimony is sufficiently reliable. The trial judge must also determine whether the witness has sufficient knowledge of the facts and expertise to render an opinion. Of note, Dr. Russell's expertise is with treating patients in an emergency room and how injuries may appear on living individuals rather than how injuries are depicted on a deceased male and in post-mortem photograph. Understood, but that's what you got to do because people don't die from dog bites. It's usually not the case. You usually treat a living person for their dog bites. But because the McAlberts selfishly decided that they were going to just leave him on the lawn, John did not get to live because he was still alive when they put him out on that lawn. He was still alive when they found him. It was just a little too late at that point because he had gone all night with his injuries. And once they did put him outside, the cold, it was very cold that night. And I think it was in the teens or the 20s. Can't remember now. So long ago when I talked about that. But it was a cold night and he didn't have a proper attire on. He didn't even have a coat on, despite one of the EMTs thinking he had a puffy coat, which he didn't. At least that we know of. So uh, he was he definitely had a chance. Let's say it that way. He definitely had a chance had the McAlberts not been so selfish and just laid him out there like trash on the lawn. Disgusting. All right, so as for the experts, disclosed on April 15th, 2024, the Commonwealth again moves in order that the defendant produce the appropriate proffers, opinion evidence, and expert reports forthwith so that Commonwealth can adequately prepare for cross examination. As to Dr. Russell, the Commonwealth moves for an order to exclude her testimony entirely, as there is no less severe sanction to ameliorate the surprise, bad faith, and outrageously delayed disclosure. And I do want to say that the Commonwealth was bringing forth discovery after the trial even started when it came to the DNA, the Bodie lab technology, which we're going to hear a little bit about in the pre-trial hearing because they talk about that, and the dog DNA. So they were still putting things or handing over discovery to the defense even at the late hour on their important, DNA, I would think is pretty important. So, um, not just that, but they were also having a really hard time throughout this whole litigation of turning discovery over in a timely manner. And they had to ask for things multiple times, and they even had to try to get subpoenas for people's phones and things like that, and they were denied. And it was just it's been a real problem to get discovery for the defense, but when the Commonwealth doesn't get the expert witness discovery in time, he wants them completely blocked. Ironic. All right, so the Commonwealth bears the burden of the proof and production at trial and cannot try the case with some simultaneously while simultaneously working to understand and rebut testimony from experts whose reports and opinions it does not have, without which the Commonwealth is prejudiced and unable to effectively prepare for cross-examination of these witnesses. Well, first of all, I would like to say maybe Laura McLaughlin, who is the one who actually signed this, um, maybe she could do some of the work here, because how are they supposed to find the time? How are they supposed to litigate this case and deal with the experts? Well, maybe you balance everything with Laura McLaughlin and not take all of it for yourself, Adam Lawley, who's done every single witness um, questioning direct so far. So I want to go back to what he says here. During a final pretrial hearing on February 15th, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, attorney Yannetti indicated no, and that the defense was not pursuing such claim. It's not exactly how it went. Lolly will play it in a second. So they were surprised by the fact that they're going to attribute John's injuries to a dog. So we're going to watch the exchange. Let me switch screens here. And let me unmute you. All right. This is the February 15th pretrial hearing. And this is where they start talking about the DNA. I'm going to play out the whole thing for you just because, or at least this whole section about DNA.
Technology. Let's talk about that first. Mr. Lally, that was to be expedited. What's the information we have from them?
So that is really the only issue and the reason that it's a joint motion to continue from my perspective. I don't oppose the motion, but the reason that it's a joint request from my end. So where we stand, I spoke with someone from Bodie yesterday.
Okay.
And really,
This is I believe it's the hair. Or maybe they were looking for particular DNA, or maybe they swabbed the car for DNA. I'm not sure. But this is supposed to be DNA, I think, from like either from the car itself or the um maybe the glass and things like that to look for John's DNA or what is it? Hold on. Let me let it play out. I'm confusing
Really,
myself now.
what I said to Mr. Yannetti, but it didn't get encapsulated within the motion, is there are the two sort of different sets of testing that are going on. So there's the hair sample with the mitochondrial DNA testing, and then there's the taillight evidence with regard to the troopers' samples that they submitted as well.
Okay. So then that has to be, so it is the hair sample. They submitted a hair that I don't know how it would have lasted. It was like on the side panel of the car, lasting through a blizzard from John's house to Dighton, and then towed from Dighton to Canton. And it was supposed to have in a blizzard, in the winds, and it stayed on this car. And it's supposedly John's hair. And even if it is, who cares? Karen and John were in a relationship for 2 years. His hair is probably and DNA is probably all over that car. So it doesn't prove anything if that is John's hair. And then we also know that in the Sally Port there was an open bag, a Stop and Shop bag, not an evidence bag, a grocery bag full of 6 red Solo cups that had what they collected on the scene of John's blood in the snow. So we know that that evidence bag with the blood was just right there and open in the back of Karen's car in Sallyport. We've saw photos, and so if there is John's DNA on the back of that car or blood on the back of that car, you can't tell us for sure that it wasn't planted or that it didn't just get there accidentally through contamination, since that bag of evidence, the Stop and Shop evidence bag was there. So that's what they're talking about. So samples that they probably swabbed the bumper and the light and all of that, and then the hair, which who cares? It's not a big deal.
So with reference to both of those samples, I anticipate initially what I was told, even with the 8-week rush expedited return, was sometime around the 3rd week of March or something like that. And so that was in part why
It's a lot more than 8 weeks.
it's 8 weeks from the date that they receive it. So and there were some delays in regard to that as far as whether or not there was going to be any observation of testing and collecting the samples, submitting the samples. It's been a bit of an arduous process. But the point, the further point of clarity that I received yesterday is that they expect, it's not a definitive due date, but their expectation is that that testing should be completed the 1st week of March now, with regard to both sets.
Okay.
My issue, though, sort of ancillary to that is, and I'm not faulting counsel for this, but I have no reciprocal discovery in this case. And my expectation is that I may be receiving some, if not a voluminous amount. I can't file a certificate of compliance and a motion for reciprocal discovery under the rules, as the court is well aware, until I've completed my discovery obligations, which I won't be able to do until we get to that 1st week of March when I get the DNA reports. So that is my reason for looking to push the trial date out a little bit in order to be able to satisfy my discovery obligations, file the motion for reciprocal discovery, and give counsel at least some reasonable amount of time to provide whatever it is they have, of which I just don't know.
All right. So while we're talking about DNA, Mr. Yannetti, do we need to be concerned about canine DNA? Where do we stand with that?
No, I think this is the only outstanding DNA issue.
Okay. So, all right. So we're not dealing with canine
No.
DNA? All right.
We're not dealing with canine DNA. Nowhere in that description did it say that they were bringing in a canine DNA expert. They're bringing in an expert medical professional who has experience treating dog bites and dog wounds, and she's going to speak to John's injuries. But how he got there, how he said, what was it again? How he said, Yannetti indicated no regarding canine involvement or canine DNA. He totally is lying. Do you see how he fabricates his um, motions, and he lies straight to the court when it comes to this stuff? Like he's been caught multiple times lying to the court. But this, yeah, so canine's involvement or canine DNA. Attorney Yannetti indicated no, and that the defense was not pursuing such claim. It was not until the opening statements that he talked about it That's bogus, man. I mean, seriously, they're trying to say, let's listen. Let's listen to those questions one more time.
All right. So while we're talking about DNA, Mr. Yannetti, do we need to be concerned about canine DNA? Where do we stand with that?
No, I think this is the only outstanding DNA issue.
Okay. So, all right. So we're not dealing with canine
No.
DNA? All right. All right. So, Mr. McDermott.
And that's it. That's all that was said. How did he get from we're not pursuing anything regarding dog related stuff? The reason they had to say forget about the dog DNA is because there were never any swabs taken of John's arm. So, how can you test for dog DNA if you don't swab for it? It wasn't swabbed. What we receive, and we're going to get into that just now, that's perfect timing. So, we're going to start watching Terry Coon's testimony. We're going to actually hold on, let me flip my screen here so I can make sure I got my notes. All right, so we're going to watch Terry Coon talk first about like what they do in her lab. So this is a forensics lab, and they also deal with species identification. So here we go.
If you could describe to the jury the type of
Whoops,
parent verification as well. We also do match comparison, which we compare samples.
why did that skip?
So we have two sides of our lab. We have a service side, which provides diagnostic testing, parent verification testing, and then we have our forensic side. We do animal parent verification as well. We also do match comparison, which we compare samples to see if they're coming from the same source, and we do species identification.
Now, what kind of cases do you typically see, like in the lab?
We can do anything from homicides to helping people see if remains are their lost pet to provide closure for them.
And what are the sort of different types of agencies that you've done work for over the years of your work with the lab?
We've worked for police agencies, humane agencies, animal control agencies, and even private individuals, anybody who believes they can use our services.
And the lab that you work for, UC Davis, is that lab accredited?
Yes, it is. It's accredited. Oh, sorry.
I'll answer my next question. As far as the lab accreditation, can you explain to the jury sort of what that process is and what's entailed in accreditation?
So our lab is accredited by a group called ANAB, and that's the American National Standards Institute National Accreditation. They accredit labs to ensure that the policies and the procedures that we're following, they set a standard for those, and they come and check our standards. Are we meeting those standards? And it's also the same standards that most crime labs are associated with.
Now, in reference to that, labs that do DNA testing specifically and only in regards to humans, the accreditation that your lab has versus the accreditation that those types of labs have, what kind of difference is there between them?
There's no difference. The accreditation is the same.
Now, if you could explain to the jury what exactly is DNA?
So DNA is the blueprint of your life. It's what makes your eye color what it is. It makes your hair color, how tall you're going to be, and you get one half of that from your mom and one half from your dad.
And where is DNA found?
So DNA is found in most cells. It's in the nucleus of the cell. You get one copy of DNA per cell. There's also another kind of DNA called mitochondrial DNA. And in a cell, that is found in the plasma of a cell, and there'll be thousands of copies of mitochondrial.
And if you could explain sort of the difference between mitochondrial DNA versus what would you classify the other type of DNA?
So nuclear DNA is, again, that individual type of DNA. It's the DNA where we could say that that's you or that's a particular animal, and it would be a statistic of, 1 in 3,000 or 1 in 350 million type thing. Mitochondrial DNA actually runs along the maternal line. So if, your mom and you have a couple kids and a grandma there, they would all share the same maternal type.
And how is DNA used in forensic science?
For what we do in forensic science, for animal DNA, we'd use it for parent verification. We use it for determining if two samples come from the same source, and we use it for species identification.
And is DNA testing just generally accepted in the scientific community?
Yes, it is.
And can you explain to the jury sort of DNA typing, that process? How does that work? What is it sort of specifically that you do?
So the main steps are when we get a sample, we need to lyse open those cells. That DNA is in the center of the cell, those mitochondria are there, but they're protected by a cell wall. So our first step is to lyse that cell wall and release the DNA. Once that is done, we want to see how much DNA that we have. And so we have something called qPCR, or quantitative PCR, that allows us to tell how much of that nuclear DNA is in a sample. From there, we would go to our DNA typing. As you can imagine, if you only have one copy of DNA in a cell, it would take a lot of cells to be able to visualize that DNA. So we have to go through a process of making multiple copies. We use something called pointers. It tells us what parts of the DNA that we're looking for. That can vary from species to species or from test to test of what we're trying to do. And we amplify that in a process called PCR. And that can be you could think of it like a photocopier. Every time it goes through a cycle, it makes a copy. So if we start off with one copy, we get 2. From 2, we get 4. 4, we get 8. And by the end of this cycling, we have millions of copies that actually allow us to be able to visualize that DNA. And then the last step is actually visualizing it. The DNA actually has to run through a matrix. It's kind of like a sponge with all the little holes. Small pieces of DNA go out first, and we can see those first, and the larger pieces of DNA come out last. So it's allowing us to both see the DNA, and it separates it by size.
And did you do
All right. So that's what they do. That's how they get their samples and whatnot. So we're going to skip ahead now to. Oh, hold on. I don't have it.
Yes, I did.
Ah, I didn't write down the time. So let me copy that link and put it here. Okay, come on.
And what samples did you receive in this case?
In this case, we received 2 swabs.
And John, may I have just a moment?
Yes.
All right. So she says that, and then there's a whole bunch of clunkiness. So I'm going to skip ahead. So they received 2 swabs. And I'm going to skip to 42. Right there.
Regard to the first exhibit that you have before you.
Whoops.
Now, place before you, marked as exhibit 780. With regard to the first exhibit that you have before you, what's up on the screen is that what you have before you as exhibit 74?
Yes, it is.
Can you describe to the jury what we're looking at in this particular photograph?
So this is the evidence that we received. The little sticker on the bottom is the one that we applied at our lab. It includes the case number, the date, and my initials. And we do this to ensure that, so that we can show that this is how the evidence arrived. It arrived in a sealed and packaged manner.
And the following exhibit number 75, that's essentially another photograph of the same packaging, is that correct?
So it's the same packaging, but it's the back of the packaging, because in this instance, that actually shows where the evidence was sealed as well, and the date as well.
And who, if anyone, or what entity did you receive this package from?
Can I look at my notes? I don't recall the exact entity.
Yes, you can.
Thank you.
So the client in this case was the Norfolk County District Attorney's Office, Adam Lilly.
And so, but as far as these
She means Adam Lally, the guy who's asking her the question.
samples from whom you received, was that the Massachusetts State Police Crime Lab?
They were the people I was in contact with about sending them. We consider the client is the one who submitted the sample on our submission form.
But the person who physically sent the sample from one lab to the other was the MSPCL, is that correct?
Let me look at their form here. There was a form that came with it as well. Let me find it. So yes, the Commonwealth of Massachusetts Department of State Police Forensic Services Division Crime Lab was the one who submitted the samples to our lab.
And are you familiar with, or did you have any conversations with a forensic scientist at the State Police Lab in Massachusetts named Maureen Hartnett?
Yes, I did.
Is that someone that you have worked with on prior cases in the past?
Yes, I have.
Now, if I could direct your attention to the next exhibit before you, number 7. And again, what's up on the screen is that what you have for you?
Yes.
And if you could just describe to the jury what we're looking at in this photograph.
So that brown packaging you saw before, this was actually what was inside of that brown packaging.
And the next exhibit.
And this is that same item that was inside, but the back side of the packaging.
So she actually took pictures of evidence.
And that shows the 2 swabs that were contained inside that packaging.
She took pictures unlike the
And that was the
police.
first swab that we selected for testing.
What's contained in those
So
photographs?
that's what they received, was just 2 swabs. We don't know that that came off of anything in particular, but they were supposed to have been from John's shirt. Because Hartnett, the one that they just talked about, she's the one that did the testing, and she swabbed all over the shirt. She didn't actually swab each particular hole or each particular part of the shirt, or identify where. She just contaminated the whole thing with the swab and went, "Here you go." Supposedly. We don't know who took the swabs because there was no evidence. There was no video of it. So how do we know for sure? How do we know that these swabs weren't swabbed on something innocuous so that it would not come up as dog DNA?
Photographs, is that a fair and accurate portrayal of what you received and sort of how you delineated those items as far as labeling them by your case number?
Yes, it was.
And for the case number, as far as the FCD and the number, sort of how was that determined, or what does that mean?
So FC always refers to forensic case. In this case, D is for dog because they were asking for dog DNA testing. If it was C, it would be for cattle. F would be for feline, but the FC is always the beginning part. The third letter always kind of denotes what species we're looking for.
Now, pursuant to receiving those particular items, are you also given any sort of identifier as far as from the outside lab or the external vendor, as far as what label they have for the sample or where the sample came from is from the outside lab?
We did receive a piece of paper that with the submission saying it was taken from a shirt.
And do you recall specifically what the item number was or where it was swabbed on that shirt?
No, do you remember that?
I do not. It would be on that piece of paper, I believe.
Would that also be delineated somewhere within your report and your findings?
The case number would be in our findings.
And I'm sorry, not specifically in your findings, but within the context of your report with that.
In the report, the case number that they gave us is listed in the report.
Your Honor, do you have your report with you, ma'am?
Yes, I do.
Your Honor, with the court's permission, I would ask that the witness be allowed to refer to a report to that information.
Yes.
Okay. Yes.
And I'm sorry, what is that?
Did you want the case number there?
The case number, the item number.
So the case number was listed as MSCLP number 22-02184, item 7-18.16.
Now, with reference to these samples, did the samples arrive as you expected as far as their packaging and things of that nature?
Yes, everything was arrived sealed, and as you saw, that was documented in our with our photos, and it's also documented in my notes.
Did you test all of the samples that were submitted, ma'am?
Yes, we did.
And what is it that you were asked to test?
We were asked to determine species via canine qPCR. qPCR is that quantitative PCR that tells us how much DNA is in a sample, and it is specific for canine because the next goal they asked is if we could develop a DNA profile to possibly use for a comparison with a reference sample to be submitted later. If we weren't able to see anything with canine DNA there, we were asked to do our species test called Meat ID.
Now, first, with reference to the sort of nuclear DNA testing that you did, what were the results of that initial testing?
For the canine qPCR testing, we did not see any canine DNA.
So the Commonwealth brings in this particular witness to say there was no canine DNA present. So you just opened the door for canine DNA talk, even though they're not even talking about DNA. They're talking about something completely unrelated. I mean, not unrelated, but they're talking about the injuries on John's arm and not the bogus DNA swabs that somebody took without any record of.
And when you say, just if you could explain to the jury or expound upon that, as far as what are you looking at and what are you seeing or not seeing that leads you to that?
So the canine DNA we're looking for in that is that nuclear DNA, that DNA that's used for an individual, because the idea was if we see canine DNA in the quantitative qPCR, then we know we have canine DNA on that swab, and we can try and use that to develop the DNA profile for a later comparison.
Now, per the questions that you were asked or what you were asked to test, upon not finding any canine DNA from the PCR testing or the qPCR testing, what, if any, steps did you take next for further testing?
The next test we performed was our Meat ID test. It's a general species test. It tests for 12 species altogether. They would include dog, cat, bison, cattle, horse, sheep, goat, mouse, rat, pig, and rabbit. I'm pretty sure I got them all, but I can't guarantee.
Now, and I'm sorry to jump around here a little bit, but when going back to sort of the qPCR testing, can you explain to the jury sort of what is it, what type of instruments are you using and what exactly goes into that process?
So we're taking the sample and we're using primers that concentrate, that point to a small piece of DNA for canine, and it's supposed to amplify it. And every time it's amplifying, it's actually releasing a color, fluorescent color that it's measuring. So if there's canine DNA, this fluorescent color keeps popping up, and it gives it a measurement in which it will tell us how much of the canine DNA we have. But in this case, the test did not see any fluorescence for canine DNA, so it was a negative result.
And then as far as when you say canine DNA, is that dogs specifically, or what, if anything else, will be included within canine?
In this qPCR test, other canines will work, or canids will work, like wolves, coyotes, and we are now doing some further testing on foxes, but we have not concluded those tests.
Now, as far as the Meat ID test that you're talking about, that sort of second, can you explain again to the jury sort of what is involved in that and what are you doing with regard to that?
So the Meat ID test actually targets the mitochondrial DNA, which makes it a little bit better. There's, like I said, there's 1,000 mitochondrial in a cell versus that one nuclear DNA, so it's a lot more there. It's also a circular piece of DNA, so it's a little bit more hardy. It sticks around. And we have regions of the mitochondria that are specific to each of those species that I listed. And if we have, let me see this here. We have pointers that actually will give us two different peaks. If we get two peaks that are both for pig, we have a pig result. If we get two peaks for dog, we have a dog result, or the same can go for any of the species that we have. If we only get one peak, then we don't quantify that as being a positive result for that species.
And so you would need more than one peak in order to make that sort of opinion or qualification as far as species goes?
Right. We always have to have the two peaks for the species that we're getting results for.
All right, I'm going to skip real quick we're just skipping ahead to Right.
Where that could come from, that would be speculation on my part. It's a sensitive test, I can tell you. So yeah, it would depend on where that shirt had been and what the person had been doing with it.
My question, I guess, is if it, as far as the source, could that be from beyond just an animal? Could it be from some other source, such as food or something like that?
Yes, it could be from food. We have tested the meat ID test. In fact, that's what it was developed for, was for testing food products. And so we've seen it come from cooked pork, cooked bacon, in terms of the pig. I do remember those were tested specifically. Sure.
All right. Did we miss it? Did I go too far? She testifies that they found pig DNA on his shirt, his swab.
All the competition, it gives us a better chance of getting a result if there is canine DNA there, and that result was negative. So the only result we got for both those swabs was for the pig.
We got pig
And so, again, just
on
as
John's
far as the,
clothing.
canine was
They got pig. If he ate, say, some bacon or something that day, maybe they had like some appetizers that had pork product in it, and he ate that. I mean, that could get on his shirt, I suppose. But dogs also like pig treats, pork treats, pig ears, things like that. So that's something that could also have maybe been a transfer DNA item. So keep that in mind. But so yes, so she testifies no dog DNA, but we found pig DNA on both swabs. So everyone's kind of like scratching their heads, what? When we hear this. But they tried to explain it away like it was probably something he ate, but that's not necessarily the case. It could have potentially been a treat that a dog was enjoying just earlier before he attacked John. I don't know. But we are going to. I'm gonna stop here for 1 second. I gotta take care of the dogs. I'll be right back. And I'm back. All right. So we're gonna talk now. We're gonna switch gears to the cross-examination and hear a little bit more about those samples. So this clip I call garbage in, garbage out.
Good morning, Ms. Cooney.
Hi.
Just to finish that thought and start off, there was no canine DNA detected in your testing, correct?
Correct.
So when you say there was no canine DNA, that's a little bit of an overstatement, correct?
There was no canine DNA in the swabs that we tested.
Exactly. Okay, perfect. So the Massachusetts State Police did not send you any actual items of clothing or cuttings or source material, did they?
No, they did not.
As a matter of fact, the only thing to be tested were the swabs that you received, those two swabs that we saw very nicely photographed.
Yes.
You'd agree that your analysis of those swabs is only as good as the starting material with which you have to work, correct?
That would be correct. I only have the swabs to test. That's the only thing I can talk about.
So the integrity of any DNA testing has to start foundationally with the proper recovery techniques for what's being tested, what goes on the swab.
I have no idea how the agency collected the swabs.
So you're
Exactly.
left, I guess the next question would be, you're left to assume that proper techniques were used to swab the source material.
Yes.
And for a forensic scientist, that assumption may not always be valid.
Well, in cases cases can vary for us. Sometimes we get the actual source material. Sometimes we do get the swabs. It's dependent upon the agency sending it in. It depends on their policies and procedures, which I cannot dictate.
Right. So that because if the swab is not collected properly, or the source material is not swabbed properly, then you're left with sort of a garbage in, garbage out analysis, right?
But I wasn't there to see the swabs being collected, so I have no idea. I couldn't comment on that.
So that answers my next question. You were not present when the swabs were taken, correct?
No.
You couldn't oversee the collection of those swabs.
No.
You didn't take the swabs yourself.
No.
Okay. And you never did receive any of the source material from which those swabs were taken.
No, only the two swabs.
You do understand very clearly from your testimony in the UC Davis, University of California Davis lab, and the impressive work that you all do, you do understand proper protocols for evidence collection, correct?
Right, when we do collection at our lab.
For one thing, you keep proper logs, correct?
Correct.
As a matter of fact, in your report, there's a log, a couple of pages of logs that literally detail down to the minute when somebody touched those swabs, correct?
Correct.
That's because it's important to maintain those types of logs to avoid contamination on the one hand, right?
I don't know if keeping the logs prevents contamination.
That's a fair correction. The logs would give you an idea of who touched something when, and if there was some contamination, you might be able to work backwards to figure out how that contamination occurred.
Correct.
That's why the logs are in place, correct?
It's to be able to see step by step where everything was going.
It maintains a very, very specific chain of custody.
Correct.
So everybody that touches those swabs or that item, it's going into an evidence locker or coming out of an evidence locker or being tested. That's highly, highly regulated, and it's marked on a log.
It's documented in my case notes, and it's documented on our internal chain of custody.
So there's literally multiple documents that dictate, that memorialize the movement of that evidence, right?
As it goes through our lab, yes.
Right. And your lab, those criteria include the time that something was touched,
Yes.
the place where it was touched,
We don't document the place.
meaning it was taken out of this particular locker and put on this
Oh, yes.
the person that manipulated those items or that
Yes.
item? Okay. You were asked about the processes that your lab undertakes to avoid or reduce contamination.
Correct.
You were asked that by Mr. Lally on direct examination. You recall that?
Yes.
You went through what your lab and the accreditation process, the protocols that you employ to make sure that contamination is reduced, hopefully to a minimum.
Yes.
But you don't know what any other lab might employ in terms of their reduction of contamination processes.
No, I don't know those.
And you specifically don't know what the Massachusetts Crime Lab did or didn't do with this subject material before you got the swabs.
Correct.
You don't know if they took any steps, as a matter of fact, to reduce contamination of the source material before the swabs were taken.
I don't know anything about how they took those swabs.
Nope.
You agree that, for instance, if the source material had been tossed on the bottom of an ambulance floor, that could encourage contamination of that source material.
Objection.
Can you answer that question?
I don't know because we haven't tested that sort of thing.
Well,
It's an interesting question. I do agree, but we have not done any validation which would be able to prove that sort of thing.
well, I guess what I'm asking is if the item is supposed to be not contaminated, right? It's supposed to be relatively pristine, and it drops on the floor, that might encourage contamination of that particular item that's supposed to be left as pristine as possible, correct?
Again, I don't know the history of the item, so I couldn't speak to it.
All right, so I think you have to move along from that.
If in fact
I think she's just trying to avoid the question because, yes, you do have to, if something gets contaminated in your investigation, you have to either fess up to that contamination and maybe stipulate to something or basically get it thrown out altogether. It shouldn't come in because it's contaminated.
the source material was not packaged properly, could that encourage contamination?
But I didn't see how the items were packaged.
I'm not asking you that, Ms. Good. I'm asking you hypothetically. If an item, a source item, is going to be tested, is not packaged and handled properly, that could encourage contamination, correct?
I have not seen that. What I've seen when something's been packaged incorrectly is I've seen the induction of mold growth, which has prevented bacteria, which causes bacteria, which eats away at DNA. So it doesn't give me contamination, but it does mean that I don't see DNA.
There might be, if something is handled inappropriately, for instance, if something is handled sloppily before it's tested, it might reduce the validity of the ultimate test that's undertaken, correct?
Objection.
I'm going to sustain that.
There are certain proper swabbing techniques involved in the preparation of a swab, correct?
Yes.
That includes wearing gloves, using clean tools, correct?
Correct.
It includes proper documentation of the swabbing.
Correct.
The documentation might include the location or the description of exactly where the item was swabbed, is that right?
Correct.
That would be helpful in your analysis to know exactly where something was swabbed.
No.
What about any visible markings to show where swabbing was taken? Is that normally done?
Again, it varies from lab to lab what we get. I unfortunately can't dictate what every other lab does. They all have their own policies and procedures, and we work with labs across the United States and the world.
If you were swabbing something in your lab, which is an accredited lab, would you encourage marking exactly where something was swabbed so it could later be documented?
When I swab things in my lab, I actually circle on the item. There's a note with the case number, my initials, the date, and also a ruler present in the photo.
So if we have to go back, in your circumstance that you just described, if we have to go back and try to replicate exactly where that swab was taken, you could do that?
Yes.
Okay. And you think that's obviously an important protocol?
That's the protocol in our lab.
So the swabs that are used are sterile swabs, obviously.
Yes.
In fact, isn't it true that crime labs discourage, for purposes of DNA swabbing, discourage the use of swabs with wooden sticks because they can encourage contamination as opposed to plastic sticks?
I have not heard that.
The swab is supposed to be moistened, right?
I do suggest that people moisten them with water in order to make a better transfer.
And that needs to be distilled water, sterile water. Right?
Sterile water.
And you swab over an area of interest, and then generally you would photograph the area that's being swabbed, correct?
I do.
You would want to air dry that swab
Yes.
before you package it. Is that right?
When I do my collection, I don't need to air dry my swabs because the next step is actually the extraction process. So I'm not doing collection and then pausing. I'm doing collection and starting my extraction.
When you, as a matter of fact, when you're collecting biomaterial, tissue samples, for instance, blood, other biomaterials, you would not want to package those in plastic because that would encourage some sort of mold growth.
Mold and bacteria, yes.
So it's discouraged to put blood, for instance, in plastic containers.
Correct.
I didn't know that.
You certainly wouldn't put blood material that you're working with in non-sterile containers, would you?
Objection.
Sustain.
Would you put biological material in non-sterile containers?
Objection.
I'll allow that.
We don't have everything that we use is sterile. All of our tubes that we would use, or once we do a collection, we put it in a tube for the extraction process. Those tubes are autoclaved and they don't have contamination. They are sterile.
You would use a solo cup.
I'm sorry, what?
Objection, Your Honor.
Solo cup.
The objection sustained.
He said you wouldn't use a solo cup. And Lolly objected. Well, I'm sure she wouldn't.
You would maintain a strict chain of custody over that item to ensure the integrity and the admissibility of that DNA evidence?
I did, yes.
And I think we've covered this. You may have answered this already, that your personal protocol is that you actually photograph where everything is being swabbed from, correct?
Correct.
If there was DNA
Which is part of the problem too. It's like they just sent these 2 swabs. They didn't even really say where they came from. They didn't have a markup or photos of them showing where it came from off of the shirt or showing the shirt itself. Like they just get these swabs. They didn't even get, knowledge of what it came from. Not that it matters when they do their testing, but you still, for your record purposes, need to say, like, this is John O'Keefe's orange shirt, this is John O'Keefe's sweatshirt, whatever, and these are the little areas. Like you would, like she said, she actually circles the clothing item and probably puts like a little poster or something and like writes the time, date, whatever that she tested, or item number. She starts labeling them like 1A, 1B, whatever. She's going to have some kind of organizational system to track it, some kind of tracking system, which Massachusetts State Police apparently does not have, even when they are investigating the death of a Boston police officer. But what do I know?
present on a source item, and it wasn't sampled properly or swabbed properly in the right spot, then that DNA would likely not be detected, correct?
I don't know why, I don't know the circumstances or why you would swab things, in a specific spot. I know in my lab how we do things.
What I'm asking is, if you have a source material and there's DNA over here and it's swabbed over here, you would expect this swab to detect that DNA.
That's correct.
Objection, Your Honor. Move to strike.
I'll let him have it.
I'll let them have it.
What information were you provided?
But it's true, though. I mean, if John's shirt in the front has DNA, but the backside doesn't, and all their swabs came from the back, you might want to know that the front of the shirt does have DNA. I mean, it does matter. This is why these things need to be recorded and written records need to be kept.
About these 2 particular samples?
I wasn't really provided any information. I had to work with the person from the crime lab asking about what they wanted to test and try and narrow down the testing in terms of species, simply because it helps us make sure that we're directing the testing in the correct way for the answer that they're, or for the question that they're answering. So knowing the species in this case was important. It also made it so that we made sure that the testing was affordable as possible.
Understood. Would it be important for you to understand the condition of the material that was being swabbed as you engage your analysis?
I'm not.
Condition meaning, was it clean? Was it dirty? Did it have blood on it? Did it not have blood on it? Things of that nature.
No, since we don't get to choose how evidence is given to us, nice and clean with nice and clean DNA would be perfect, but that's not our perfect world we get samples from. So
Hardly ever happens, does it?
no, it hardly ever happens.
It would be important, however, to know whether or not there were obvious inhibitors on the source item when it was swabbed.
Knowing that there's dirt would be helpful, or possibly blood, because those can inhibit, but not necessarily. We don't necessarily have to know that ahead of time.
Were you told in this instance that the swabs were taken from a garment that had blood on it?
No,
Is blood an inhibitor?
it can be, yes.
Is garment dye an inhibitor?
Yes.
Were you told that there was blood on a dyed garment when you received swabs?
No.
Your report indicates that the swabs that you did test, these 2 swabs, quote, did not indicate the presence of canine nuclear DNA, but did indicate the presence of inhibitors, end quote, correct?
That was in our qPCR.
Right. You explained that, quote, this result is obtained when either, number 1, the canine nuclear DNA is degraded, is that right?
Correct.
Number 2, it's, quote, obscured by inhibition, end quote.
Quote.
Or number 3, there is no canine nuclear DNA present, correct?
Correct.
So in your report, you indicated that there are 3 reasons that you list for the possibility of not finding or not detecting the canine nuclear DNA in that sample.
Correct.
All right. 2 of those 3 reasons allow for the idea that the DNA is actually present, but it's either obscured by inhibitors or it's so degraded that it can't be detected.
The nuclear DNA.
Right. But it still could exist.
It could, yes.
It's just not, you can't see it if it's obscured, and you can't see it if it's just degraded.
Correct.
Explain.
If those items of evidence, aka John's clothing, were sitting in Michael Proctor, the lead investigator's car for 6 weeks, as we have found out in testimony. They were sitting in his car for 6 weeks. Who knows if they were moldy, if they were dried out, although not Berkowitz, Buchanan, Trooper Buchanan, who is Michael Trooper's boss, um, Michael Trooper, no, Michael Proctor, I just did what John McCabe did. Oh no. Um, but I did it differently. Michael Proctor. I meant Trooper Michael Proctor. Um, no, totally forgot. Oh, they were in his car for 6 weeks. 6 weeks bagged, however they were evident, however they were bagged. We did find that the shirt and both shirts were in one bag and the pants and the belt were in the same bag. Those are all supposed to be bagged separately. So they already there in their bagging process is, defying protocols for contamination. So it's just really bizarre, all the things that they have been doing in this case.
How an inhibitor works in your testing.
Excuse me, an inhibitor just actually stops the PCR process from happening. And so therefore you would see no result.
So did you find inhibitors in this sample?
In the nuclear DNA testing, yes.
And was that the qualitative polymerase chain reaction test, the qPCR test?
Yes.
And in fact, an inhibitor is pretty much any chemical that's literally going to inhibit the enzyme from helping make the copies.
Correct.
So again, if those items of clothing were sitting for 6 weeks, they were soaking wet, we were told, when they took them off of John. So if they weren't dried properly, water, snow, obviously would degrade DNA also. So it's possible that there was dog DNA present on John's clothing. It just wasn't detectable as normal as it would be normally, but there were signs of the possibility for it.
Certain dyes inhibit,
Yes.
and certainly blood inhibits.
Heme from blood, yes.
And because of that, at least in that sample, the nuclear DNA sample, you're not saying that there was no canine DNA there. You're saying that the testing did not detect it.
In the qPCR nuclear test, correct.
And you've heard, obviously, there's a famous quote in science that the absence of evidence is not evidence of absence, right?
Correct.
Can you describe to the Jews what that phrase means?
Objection.
Sustain.
Hi,
Just because you don't find something means it's not there.
Objection.
Sustain.
come on.
You were able to detect the presence of pig DNA, right?
Correct.
And I think you said on direct examination that could come from a number of sources, including food sources, right?
Correct.
Could come from dog treats.
Pardon me? Yes.
Could come from dog treats. But like, there are dog treats that are pig ears, literally. Right?
Objection.
Allow it.
All right.
I believe so.
Or it could be that the shirt that was the source material was contaminated and not properly preserved.
I can't say where that DNA came from.
You're not aware of any feral pig populations in Massachusetts, are you?
I'm not.
Dog saliva would obviously be a good and a rich source of DNA, correct? Do you agree?
It depends on the context. We have cases where, I can refer to 2 cases that we did recently where there was small bites and we were able to get nuclear DNA from those sources.
Because it was probably saliva.
Yes.
Right. So saliva contains active, living, growing cells that slough off in the salivating process, right?
Correct.
That's why oftentimes for 23andMe or other companies, they want you to swab it inside your cheek.
Right.
DNA, right?
Yes.
So that's a relatively rich source of DNA, you agree.
It depends on the amount of contact in the attack.
However, dog claws, the claws, would not be a good source of DNA, would they?
No.
And the reason for that is because the claws are, like human fingernails, they're made of keratin.
Correct.
Keratin is dead, hardened cells,
Correct.
and not a good source for DNA.
Not in terms of scratching. We can do something where we pulverize them and we can get DNA from them then.
You have to have a claw.
Generally, yes. We have to have the claw material.
I spoke over it a little bit, but I want to make sure we're clear about that. We're talking about you can possibly get DNA in a mitochondrial test if you have the claw and pulverize the claw.
Correct.
Possible to find some DNA. But in terms of touch DNA,
We don't.
difficult to find it from a claw.
I really can't speak about touch DNA because it's not something we tested or validated in our lab.
So you didn't have any claws that you tested here.
No.
As a matter of fact, you were just testing swabs from a shirt.
Correct.
That were sent to her by the MSP, the same people who are alleged to have, planted evidence in framing Karen Reed. And I'm saying alleged, but I absolutely fully am 100% on board that they did plant evidence and tried to frame her. So I'm just trying to say alleged.
And you've already agreed that keratin is not a good DNA source because it's dead cells. not
Correct.
alive. Would you agree that one of the reasons that it's difficult to detect canine DNA. It was difficult to detect canine DNA in this case is because it was potentially degraded, right?
Objection.
Ask the question differently.
Sure. In your report, you indicated that there were two obvious possibilities of not detecting the DNA. One was obscuring because of inhibitors, and one was degradation. The DNA would be too degraded.
Again, that was for the nuclear canine DNA.
Understand? So, to be clear, in your conclusion, you're not testifying today that there was no dog DNA on that source shirt that was swabbed. You're saying that the two swabs that you got did not detect the DNA, correct?
Exactly.
In our meat ID test, we also have a test for an inhibitor. It's also called an IPC. It's the same initial internal positive control. And that's what did not work in the nuclear testing. It did work, and it worked very well in the test on the meat ID. So there wasn't any inhibition that we were seeing on the meat ID test.
But that's the ID test that you found pink.
Right, but it also was testing for dog at the same time.
But when you tested for dog for nuclear DNA, that test was either inhibited or so degraded that you couldn't tell.
For the nuclear test, yes.
Thanks. That's all I have.
Hey, Mr. Lally.
And Lally tries to save it, but he doesn't. There's no point in listening. All right, let's go. I have a final note that I wanted to leave you guys on. So this is, let me make that a lot bigger for you guys. This is a tweet from Lana Del Turtle. She has been tweeting about this case. She knows a lot about the law, and she has a lot to say about this latest motion. And I encourage you to go over there and follow Lana Del Turtle, and stay up to date on this case. All right, I'm going to just read a few paragraphs, not the whole thing, but just a little bit. So, make it a little bit bigger if I can. Oh, there we go. Okay. So she's talking about this motion that we read, the whole garbage motion about striking all of the defense's witnesses. So regarding this motion, Lana Del Turtle says the legal argument is Miss McLaughlin's motion papers go something like this. Karen Reed cannot possibly get a fair trial and the ends of justice cannot possibly be served unless the court strikes all of the defense team's proposed testimony, leaving Karen Reed entirely without an expert. Pretty much. That's pretty much what they're trying to do. And she says, read it again because that's worth understanding. They're basically saying she can't get a fair trial, and this prejudices us, and we need to strike all the testimony. Which is such. I surely hope that Bev does not. Bev has come around, I think. Personally, she's very, very prosecution leaning. However, I do think that she has kind of been coming around and seeing what the rest of the world is seeing. Only because she hasn't been as snide and rude with the defense team, but she still is really rude and condescending to them, but not as bad, in my opinion. All right. So moving on, McLaughlin's argument relies on two court decisions in which a criminal defendant's evidence was stricken because of his failure to provide the Rule 14 disclosure. So it's the discovery disclosure, which they're arguing they were too late, and so you should just strike the testimony altogether. In one of the cited cases, so one of the cases that the Commonwealth uses to try to argue their case, we find that the failure to disclose was conceded to be a deliberate tactical maneuver by the defendant. So in those cases, it was intentional, deliberate. The trouble is, the initial evidentiary rulings in both cases cited by Ms. McLaughlin, this Commonwealth versus Reynolds and Commonwealth versus Pava, were reversed on appeal. So both of those cases were reversed, meaning probably they got a new trial because the evidence wasn't let in or something to that effect. So while the cases cite the broad general language described by Ms. McLaughlin, the actual ruling in both cases is the exact opposite of the principle upon which Ms. McLaughlin urges Judge Canoni to rely on. The real holding of those decisions is that the court must not exclude relevant expert testimony proffered by the defense where the Commonwealth is neither surprised nor materially prejudiced, and where the defendant would be deprived of her ability to provide a rebuttal to the Commonwealth's own experts. And final thought, I like this quote a lot. We ought not have to remind the Commonwealth once again to do the right thing, cautioned by the Supreme Court in the Commonwealth versus Rodriguez Nieves. I don't know how you pronounce that. All right, let's take a step back once again, look around, and ask ourselves, is the Commonwealth really, in the words of Justice Wendlet, doing the right thing? Or is something else going on here altogether? So, what do you guys think? Do you think Judge Canoni is going to deny or allow this motion regarding expert witnesses? I really, really hope that she does not allow this motion to go forward because that would cut Karen off from her defense. And at this point, I think Lally just knows he's done and there's no saving this trial. And so he's just trying every tactic to try to, I don't know, to try to make it harder and harder for Karen Reed and her team, I guess. It's the only way I can think, or that's the only thing I can think of. He he has to know. Come on. I mean, he has to watch these shows too on YouTube and even Court TV and all sorts of YouTube creators now that didn't know anything about it. Once they started watching the trial, they have now realized what we've all realized is that there's something really fishy going on here. And at this point in time, Karen's not guilty for me. I mean, she's I could be dissuaded and say, okay, maybe she's guilty if I saw some kind of evidence. But at this point in time, we're 6 weeks into the trial and not one conclusive piece of evidence tying Karen to the crime or to even having been drunk. We know that she went to a bar and drinks were ordered and things like that, but we don't know how many she had. We don't have proof. And you kind of tried to. Can you hold on one second? And one other thing about Sergeant Buchanan, who we still get to see on Monday on the stand, because Cross is not done with him. Alan Jackson's not done with him. So he's still on the stand Monday, and what am I gonna say now? He testified. What did he testify to? Hold on one second. So what he testified to was expert opinion type questions. So he testified to what the dog injuries and what John's injuries may have come from, and he said a lot of things that he should not have. And Judge Canoni did let a lot in that she shouldn't have regarding his testimony regarding injuries and trying to be, play the expert as a medical professional expert. No, he's not. He's not one of those. So he can't tell us where any of John's injuries came from. But yet they did. He did testify to having some idea where John's injuries came from. A lot of it, I think, was um, potentially sustained, but the jury heard it. They know. They know what's going on. This Commonwealth is really trying to pull a fast one on all of us. They think we're all absolutely stupid, and it's insulting. Sitting there watching this and sitting there watching the Sally Port footage going, There's just something not right about this footage because why did somebody just step out of the passenger car or passenger side and then why is everything backwards? And they really thought that we would not know, that we wouldn't notice these things. And then that's just how it recorded. I got news for you, Commonwealth. You're all going down. Whoever doctored that video, you better believe the FBI knows somehow, some way they have it. They have to because they've been watching this case for forever. So they have to know that these people were going to pull this kind of fast one by creating doctored or proctored footage, as we're calling it. It's just crazy. What do you guys think? Let me know in the comments below. I thank you guys so much for being here. I appreciate you, and I really hope that you stick around and stick with me for more episodes of the Canton Cover-Up and other cases of corruption and cover-up and crime that the seedy side of the crime that nobody really talks about. That's the kind of stuff that I want to talk about and what I care about. All right. So thank you again. I'll see you guys. Take care. Bye.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.